2023 presidential election has shifted to the courts. What's your overall thought about this?
Shifted to the Supreme Court. Well, it's good for our electoral jurisprudence. As you know, the final court of the land is the Supreme Court, and decisions reached at the Supreme Court are only appealable to God. In essence, they are final. And so there are a lot of pressing issues that this petition, especially at the initial court, have raised, that it will be good for the Supreme Court to make a final judgment or decision on those issues and put those matters to rest.
So it's
a good development.
Right. So let's get to the issues. The presidential candidate of the PDP has now filed an appeal at the Supreme Court. He's seeking nullification of the appeal court judgments. Do you see this happening?
Yes. Well, yes, he wants the decision of the presidential election petition court overturned. Well, the matter is before a court, right? And it would be wrong to make allusions as to where the court will swing. I would rather look at the issues they have raised. They have raised 35 grounds of appeal, stating errors that they believe that the court has made. And I would think that what the Supreme Court would do would be to distill those issues. You have 7 justices this time who will look at it and hopefully address the issues and give full letter of the law to those issues. Whether or not the matter will be trashed on appeal, I believe that the decision at the appeal court, which is the trial court for presidential election petition cases, was sound. I believe that the justices, I addressed the issues as succinctly and as detailed as possible. And I think that the unassailability of certain key things in that judgment, I believe that even on appeal will receive some measure of ratification. But we cannot preempt the decision of the Supreme Court, and parties have just filed. One has not really looked at their appeals succinctly to really understand the basis upon which they are saying that the court has erred. Right?
But some of them are now in this reports that have been reeled out. I mean, 35 grounds of appeal at the Supreme Court. Will that be enough to upturn the appeal court judgment? Well,
it is not the number of grounds that upturn the judgment. It is whether or not you can show the court that the trial court has erred in law. Remember, appeals are not based on facts. None of the parties can bring in any facts. They are only looking at the judgment, and based on that judgment, they are saying that the interpretation of XYZ by the courts was wrong. And we're asking you, the Superior Court, to interpret it correctly based on what we believe should be the interpretation, right? So in simple layman's English, that's what both parties have gone back to court, because just before we're coming in, I got word that even the Labour Party have also filed, and they have 50 grounds of appeal, right? So if you have one ground that is solid and that the courts find merit in, then definitely they will allow the appeal, or they will dismiss. And if they feel that there's no merit, they will dismiss the appeal. But the benefit for our electoral jurisprudence and the benefit for the electorate is that it is important that this matter even gets to the Supreme Court for certain issues to be decisively addressed.
What are those issues?
Right? For instance, the issue of the FCT. Whether or not the word "and" means compulsory or whether it's an inclusive phrase, the court will now be compelled to make a clear decision on that fact, and that will put to rest, whether FCT has a special status. The Court of First Instance, which is the Court of Appeal, have said, look, you cannot accord the FCT any special status. They are just as any other state. And so you cannot give them that special leverage. The petitioners are disagreeing with that assertion, and they are disagreeing with the line of the court, right? I think that they feel that the Court of Appeal, even calling such interpretation ludicrous, amounts to a perversive judgment. So it's important that the Supreme Court looks at the issues now. One very interesting definition of law back then in jurisprudence is the prophecy of what the court will do in fact, and nothing more pretentious is what we mean by the law. And so I'm very interested to see how that decision plays out and its impact on our judicial system.
Right, so let's look at what Atiku Abubakar is saying through his lawyers. He's insisting that the tribunal made a serious error in its ruling. But experts say the 12-hour judgment was painstaking.
Yes.
What's your thought on that?
I agree that the court took time to explain. Elections are very emotional endeavors, especially for everybody on every side of the divide, right? And so if you listen to it dispassionately, I doubt that you will be able to fault the judgment of the appellate court, especially on certain facts. What is playing out, and I think that, and I have said this in other fora, what is important is that we go back and look at the inadequacies, the shortcomings of our Electoral Act, and see those gaps that have now led to some of the issues that we are now having to grapple with. When the Electoral Act was passed and it was being celebrated for allowing for electronic voting, I asked the question, does this act allow for electronic transmission of results? Guidelines do not constitute part of the law. The act allows INEC to make guidelines through which it can carry out its objective as stated in the act. Can those guidelines be interpreted to form part of the Electoral Act? These are very germane questions that we must now ask ourselves. And flowing from this, we must now go back to the drawing board to now see where does the Electoral Act need some tweaking? Where do we need to rejig? What are the things we need to add? What are the things we need to modify? What are the things we need to expressly clarify? As we speak today, the court has said those guidelines are within INEC's purview. INEC can make regulations to carry out its objective under the Act. They did that. Did they meet it? That is in the Court of Public Record, in the Court of Public Opinion.
Absolutely.
That INEC should receive a few knocks for how this election, or more than a few knocks, for how this election has played out. But let's look at the facts. The guidelines that are being held so tightly to do not form part of the Electoral Act. And so, like I said, let's wait for the Supreme Court to address these issues, and put it to rest. And then after the courts have done their part in the electoral process, then maybe we need to go back to the drawing board and see how to amend the Electoral Act to reflect these issues that have led us to where we are. Very importantly.
So, in your words, if you're saying that the court took time to explain, are you in other words saying the appellants may be wasting their time at the Supreme Court?
No. I will again repeat. It's important that this matter gets to the Supreme Court. Right. Because, like I said, decisions at the Court of Appeal are lower than decisions of the Supreme Court. Decisions of the Supreme Court become law. And that's what we call judicial precedent, right? inclusive of all decisions of the court are judicial precedent. But where there is a decision of the Supreme Court, no other decision can overturn it except the Supreme Court in another matter reaches a decision that contradicts. And even in that instance, it allows the persons relying on both contradictory judgments to pick and to handpick, right? So it's important that this matter gets to the Supreme Court and they decisively address these issues. It will help our electoral jurisprudence. It will help clarify the issues.
Right.
But I believe that the Court of Appeal took its time to explain its decision, to give a basis upon which it arrived at its decision. And I do not think that it can really be assailed.
All right. So another interesting ground is that Atiku is requesting the Supreme Court to overturn all the findings and conclusions by the tribunal because they did not accurately represent the foundations of these petitions. So my question is, will you say this is a case of the tribunal judgment?
No, I wouldn't say that. But like I said, let's not get too entangled in the arguments of the parties at this time. Parties have argued, they filed. The trial courts for a presidential election petition has reached a decision. Now it's time to either put a seal on it or throw it out. Let's wait, right?
Well,
the court has barely 70-something days to reach that decision.
I feel like it's interesting, or it's, I mean, good for you to say that, but we are not lawyers, so it's important for us to understand some of these things.
Well, the danger of the public perception of the decision of the Court of Appeal in this presidential election petition have been from the divergence of opinions that have permeated the petition, the proceedings, and the judgment. Because what you have is that people come and they forcefully, explain their points of view, what they think that the court should do, and what they do not think that the court should do. And then this builds on the minds of the populace, who now form allegiances, so to speak, as to what they expect the court to do. And so when the court now does its job, it's difficult to disabuse the minds of the people who have already formed, a mindset, so to speak, based on opinions. And which is why I'm very wary of, drawing the lines very clearly.
So if you say INEC deserves some knocks, where did you think INEC erred in this election?
So let's look at the elections. The elections were not perfect. There are things that could have been done better. And INEC needs to do better in terms of managing the processes. Reliance on technology. The bone of contention of the petitioners have been that you said you will transmit electronically. You said it was cast in stone. You said that's what you would do. And then you turned out to do the opposite. The courts are saying the Electoral Act does not obligate you to do what you have said you will do. But then there is a moral burden on you. And it is the failure to meet that moral burden that INEC must now ensure that it does not happen again. When you make a commitment to people, you stick to that commitment. And then our Electoral Act needs clear amendment of the prosecutorial aspects for electoral offenses. The problem we have in this country is a lack of consequences. And if you look at the process for prosecuting electoral offenders, it's actually, it puts the burden on the Attorney General of the state, right? And if we look at it, if you look at that, the Attorney Generals of states are card-carrying members of political parties of the states that they are in, because they are appointees of the governor. I think that it's important that the act now go back to the drawing board. provide very clear provisions for prosecution of electoral offenders. When people know that there are consequences for electoral offenses, clearly laid out consequences, I think that we will have, better behavior, right? But what does the Electoral Act say? The Electoral Act does not say that it must be perfect. It says there must be substantial compliance. Can you say that the last election did not meet that substantial compliance threshold? I doubt it. I do not think that any of the parties will say that, right? And so, what are the challenges that have brought us here? Parties believe that in some places they were not allowed to vote. Some believe that in some places they were disenfranchised. If INEC did its job as it should, I doubt that the petitioners will be in court with as much litany of complaints as they have come, right? And that's why I say they need to look inward, right? They need to look at the modus operandi. We even need to rejig the entire system. I was saying to Uncle Sam and Veronica, before the elections, that look, we need to really look at technology and how we are relying on technology for our electoral processes, and understand that technology is a bespoke, it has to be bespoke, right? Technology that works in America is not technology that works here. But we have technology that we can deploy, that work here. And I had said this. I said, any technology that wants to rely on internet access may not be effective, because internet penetration in this country is still relatively low. Let's not use Lagos, Port Harcourt, and Abuja as a bubble. There are rural areas, but if you decide to rely on same technology, I doubt that there's any part of this country where people do not have SIM cards and telephones. So I think that it's important that INEC sits down with, we have talent, right? We have technology talents. I work with startups, and I know very clearly, that there are a lot of young talents, intelligent persons who can contribute to the automation of our electoral processes, and prevent some of the shortcomings that we have faced in the last elections.
All right. So, Obi's 51 ground of appeals at the Supreme Court. What's your view on this?
Sorry?
Obi's 51 grounds of appeal at the Supreme Court. What's your view on this?
I haven't looked at it, but I do not think that it will be too much of a departure from
the norm.
What Atiku and his team, Atiku's team, have filed. But like I said, and I repeat again, the Supreme Court's ruling on these matters will put finality to some of these issues, and that will ensure that we do not have certain things being litigated on, right? So it's good. It's good. Everybody must have their day in court, right? So the petitioners are within their legal rights to go to the court.
Right.
They have exercised that right. And so we look forward to the decision of the court. Will they be, dismissing the appeal and upholding the decision of the Presidential Election Petition Court? Or will they be, allowing the appeal and upturning that decision? It's for the justices to make.
Right. So, we're having this kind of conversation, so it's important for us to touch on this. And thankfully, you're a lawyer. What do you think is the danger of letting people heap criticism and threats on the judiciary?
Very wrong. Very wrong. You see, the judiciary remains the last hope of the common man, irrespective of what anybody says. Our courts, if the moment we lose that faith in the judiciary, we lose our consciousness and reliance on the law as a remedy to our issues. And so, do we want a place where might becomes right, or where abuse becomes the order of the day, or where extrajudicial avenues are utilized to resolve disputes? No. So the judiciary cannot be vilified. I do not support the bashing of the judiciary, not just because I am a lawyer, right, and I am obligated to uphold the tenets of justice and ensure that the instruments of justice and the institutions of justice are respected, but also because it leads to a dangerous precedent, right? And, you know, judges must be allowed to do their job. And judges are obligated to do their job judiciously, right? To ensure that justice is not only done, but manifestly seen to be done. But there is also a very thin line, and there's procedure. And so while we heap the blame on the courts and say, oh, you know, certain things have not been done, certain things have been done, people must also understand that there's something called process. There's something called the procedure, right? I'm in your studio today. If I am not mic'd, you can't hear me, right? And if I do not follow certain protocol, it will be impossible for me to sit here, no matter what your intentions are, and no matter how beautiful or how intelligent or insightful what I'm saying would mean, right? Because I followed certain procedures as laid down by you. And so that's how courts work. And the public must understand that there are procedures to be followed when it comes to judicial issues. I do not support the vilification of the judiciary. Like every institution, there will be, you know, certain members of the judiciary who may not, you know, be carrying out their duties, you know, at optimal level. But definitely the judiciary remains the last hope of the common man, and I do not think that it is right.
All right. Thank you so much, Mr. Omori. I mean, these are fresh appeals, and we'll be here to monitor the updates as they unfold. Thank you so much. I've been speaking with a lawyer, Mr. Omori Edohiawere. Thank you so much for joining us tonight.
Thank you very much.
And thank you very much. That marks the end of today's episode of Politics Tonight. But the conversation continues from here. Get in touch with us on X, formerly Twitter, at TVC News NG and at Olajumoke OO using the hashtag Politics Tonight. We're also on YouTube at youtube.com/TVC News Nigeria. I am Olajumoke Olatuji. Good night.